my name's Hugh Reed. I'm the president and CEO of Reed Bar Review. I'd like to talk to you a little bit about contracts. Contracts underwent a transformation this year. That is, contracts used to be tested in 10 categories. Now, the bar examiners tell us contracts is tested in 6 categories. And of course, the law of contracts also applies to the Uniform Commercial Code, that is, the law of sales. Approximately 8 to 9 questions of the 34 questions that you'll be tested on in contracts are going to cover the law of sales. So it's a good idea always to ask yourself, number one, is this contract a service contract or common law contract, or is it governed by the law of sales? Because I can tell you the rules are quite different. And don't make the mistake, as one dean of a law school recently did, that the law of sales only applies to merchants. It doesn't. It applies to everybody selling something. So if I sell you my lawnmower, the law of sales governs. So here are the instructions for contracts, and you've got to know them. First of all, 6 major categories, and you ought to keep track of all the questions you miss, not only for multi-state purposes, but also for essay writing, of what category you have to focus on. In other words, where your apparent opportunities are. So it's important in contracts to understand where you've been tested and where you didn't get the right answer, because that's where you need to focus. You can't possibly learn everything about every subject, no less than to learn everything about all the subjects that you're going to be tested on the bar exam. Now, I take the bar exam every 6 months, and that's important to you. Up to 60 questions out of 200 are repeat questions for statistical equating purposes. And I want to make sure that our candidates, who score very high on the multi-state on a general basis, understand how this stuff is being tested. And you can only get that by taking the exam. You're to assume that Articles 1 and 2 of the Uniform Commercial Code have been adopted and are applicable, but that the 2001 and 2003 proposed amendments to Article 2 have not been adopted. What does that mean? Well, the 2001 and 2003 proposed articles increase, for example, the statute of limitations amount from $500 or more to $5,000 or more. Very few of any states have adopted that. So the rule is $500 or more for statute of frauds purposes. And approximately half of the questions on the MBE are going to be based on categories 1 and 4, that is formation of contracts, performance, breach, and discharge. And the other half of the 34 questions are going to cover all the rest of these 6 categories. Now, the 6 categories are: number 1, formation of contracts; number 2, defenses to enforceability; number 3, parole evidence and its interpretation; number 4, performance, breach, and discharge; number 5, remedies; and number 6, third-party rights, including third-party beneficiaries and assignment of rights. All right, so very, very important, and what you need to do is work these questions, multiple choice questions and essay questions, and keep track of your misses by categories. All right, now, chances are in contracts, they're not going to give you a doctrinal name. In other words, they're not going to say inadmissible because of the statute of frauds, or this contract falls under the pre-existing legal duty rule. You're going to have to understand these doctrines, but they're not going to give you the answers and say that these are the answers. So you have to understand them, you have to be able to apply them. And that's why the multi-state bar exam is very, very important to you, because no one who scores low on the multi-state passes their essay part. So the multi-state score is reported in a matter of days to the bar examiners or law examiners in your jurisdiction. And the National Conference of Bar Examiners, the proponent of the multi-state bar exam, have gone to great lengths, published study after study, to validate the examination, and therefore they've convinced examiners around the country that students will do approximately as well on the essay part as they do on the multi-state. So in larger jurisdictions, for sure. They're going to look at your multi-state score, and they're going to say, well, presumptively pass, presumptively fail, based on that score alone. All right, I only have a few moments, so what else do you need to know about contracts? Well, I think it's important to have a checklist approach. Now, most of you know I'm a former military pilot in charge of pilot training for the Army, also a former airborne ranger in my younger days with combat experience. And pilots and airborne rangers rehearse about the same way. In other words, pilots have to apply their emergency procedures using checklists and memory devices. Rangers, when they practice for missions, have to do it by the numbers. There's no time to make stuff up during combat conditions. So, on the bar exam, high anxiety condition, you're going to have to remember things. You're going to have to remember, for example, is this a contract? Well, does the UCC apply, or does the common law apply? All contracts have the elements of COALL, C-O-A-L-L. That is, consideration, offer, acceptance, legal subject matter, legal capacity of the parties. Are there any defenses to contract formation? Well, I remember them with DUI mule, general defenses, and my legs, M-Y-L-E-G-S, for statute of frauds. DUI mule stands for duress. U, undue influence. I, illegality. M, misrepresentation. U, unconscionability. I, or L, lack of capacity, lack of consideration, and E, existence of mistake or misunderstanding. Or my legs, statute of frauds. Marriage, a contract in anticipation or in consideration of marriage. Y, a contract which cannot be performed within a year. L, land sale contract, including leases over a year. E, an executor's contract, an executor paying the debts of the estate from his own funds. G, goods, $500 or more under the Uniform Commercial Code. And S, a suretyship contract. Suretyship contract, an idiot with a pen, a person who signs for apparently no good reason. So, use your checklist. In other words, do we have a contract? Number one. Are there any defenses to contract formation? Number two. Number three, are there any conditions that must be satisfied, fulfilled, or excused? Number four, has a duty to perform been discharged? I remember discharge with PILAB, P-I-L-A-B, performance, impossibility. Legal discharge, agreement, or breach. So, PILAB, performance, illegality, or impossibility. L, law or legal discharge. A, agreement, and B, breach. All right? The difference between substantial breach and the perfect tender rule, often tested. In other words, you've got to know the most often tested distinctions between the common law and the UCC. Common law, statute of frauds under the 2201 of the UCC. Option contracts in the common law, merchant's firm offer under 2205. Mirror image rule, common law, additional terms under 2207 between merchants. Pre-existing legal duty, common law, contract modification, 2209. Contract fails for indefiniteness, common law, contracts formed even though we have missing terms under the UCC. In other words, the UCC has a whole bunch of gap fillers for us. Substantial performance under the common law versus perfect tender rule. So, contracts tested in 6 major categories. Make sure you understand where you're missing these questions. Make sure you document the questions, and make sure you understand some of these subtopics are more important than others. If you have any questions about contracts or any other subjects, either tested on the multi-state or on the essay part, or the multi-state performance part or performance part in California, please give us a call or email me, and I'll get right back to you and try to help you the best we can and as quickly as we can. Thank you.